Thank you, Mohammed, for that very kind and generous introduction. Your Excellencies, distinguished delegates, ladies and gentlemen, it is indeed an honor and a privilege for me to be here as a speaker at this first international conference of the Saudi Center for Commercial Arbitration. My topic today is performance guarantees in construction. And let me see if I can get my slides on. As many of us familiar with the construction industry, security in the form of guarantees is a common feature of most construction projects. It is common for the owner or the employer to require that some form of guarantee be taken out by the contractor. This is true in the Middle East as well as abroad. Bonds and guarantees may be used to secure advance payments. They may be used to secure contractor performance or to release retention monies early without losing security. International commercial arbitration is also a main feature in construction contracts. So within this brief talk, I propose to look at the types of guarantees that are available to secure performance on construction contracts, and to also look at the interface between the underlying contracts of construction and these contracts or these guarantees, both in contract drafting and in arbitration. Unfortunately, there is little consistency in the terminology applied to guarantees and bonds, which can cause some confusion. So I propose to start by taking a look at the types of guarantees that are generally available. There are essentially two types of guarantees: those payable on demand and those requiring payment when substantial conditions have been satisfied by the beneficiary of the guarantee. More specifically, the security itself will impose on the issuer one of two obligations. It'll impose either a primary obligation to pay a specified sum of money on the occurrence of an event, which often is easily demonstratable, or the presentation of particular documentation. It can also impose the alternative is to impose a secondary obligation on the issuer. The secondary obligation will ensure that if a party fails to perform a contractual obligation, if a third party fails to perform that obligation, or make payment owed to the beneficiary under the underlying contract, then the obligation of the guarantee issuer would kick in. Generally speaking, security instruments imposing a primary obligation are referred to on-demand guarantees, and those specifying a secondary obligation are referred to as conditional guarantees. Now, the requirement to issue that guarantee will be contained in the underlying construction contract. And that is also the case with the fitted conditions of contract, the 99 forms, which are widely used in the international arena. Now, the requirement to issue performance security or security for performance is found in clause 4.2 of the fitted conditions of contract. Subclause 4.2 stipulates that after providing that the employer may only claim amounts to which he is entitled, the clause sets out the conditions for the ability to call on that performance, being a failure to extend the guarantee itself, a failure to pay monies owed either determined or agreed by determined by the engineer or agreed by the contractor, or a failure to remedy defects within a prescribed amount of time, or fourthly, if any of the conditions giving rise to termination for default under 15.2 are evident without a requirement to issue a termination notice. FIDIC takes a neutral position on whether the performance security that is issued is an on-demand security or a conditional security. Both are contained in Annexes C and D in the conditions of contract. So if we start by looking at the on-demand, if the employer chooses to require an on-demand performance security while using the FIDIC standard forms, the 99 standard forms, they would choose the form that's provided in Annex C. And this form of on-demand guarantee itself sets out that the only condition for payment that the employer it needs to provide to the bank is a written statement stating that the contractor is in breach of its obligations under the contract, and the employer must also specify the respect in which the contractor is in breach. These are important conditions as they require the employer to observe certain discipline before calling an on-demand guarantee. So, as we see, the employer must state that the contractor is in breach and the respect to which the contractor is in breach. So the question would be, we saw the conditions under which the employer would be entitled to make a call on the performance under 4.2, and we saw the conditions under Annex C stating a breach. The question would be, now, can the contractor rely on the conditions set out in 4.2 to request a court or an arbitral tribunal to restrain a call on this on-demand bond? Generally, the answer is no. As far as an on-demand guarantee is concerned, as the conditions that are set out in 4.2 are simply conditions that are in the underlying contract. They are conditions and obligations on the contractor and the employer. So if the employer was to disregard these conditions and still make a call that is compliant with the on-demand guarantee, stating that the contractor is in breach, the bank would have to pay. While the employer may be in breach of the underlying contract by disregarding the conditions of subclause 4.2 in itself, the money will typically have been paid already by the bank, and the resolution and the determination of the employer's breach would be made subsequently by a tribunal. An example of this is a Bjugstrøy case. In this case, a subcontractor was engaged to supply and install curtain walling for an office development in Russia. The subcontractor was required under the subcontract to procure an on-demand bond in favor of the contractor, which it did. The subcontract provided that in case the subcontractor fails to comply with one of the contractual duties or obligations, and if the default exceeds a period of 10 days, after the contractor gives the subcontractor formal written notice of remedy, then the contractor in this case would be entitled to call on all or part of the guarantee. The subcontract also contained an arbitration clause with a seat in London under UNCITRAL rules as administered by the LCIA. The contractor made a successful call of the bond. And the subcontractor responded by seeking an injunction against the contractor, restraining it from making any further calls on the bond. Now, the tribunal was not formed as of yet, so we talked yesterday about court support for arbitration. It was the English court to which the subcontractor approached, and the English court granted an interim injunction against the contractor pending a full hearing. At the full hearing, the subcontractor argued that the conditions of the subcontract actually stipulate that to be able to call on the performance bond, the subcontractor had to have failed to comply with one of the contractual duties, had to give formal notice, and the subcontractor remained and that default had to be for at least 10 days. I think I'm going a little